You're watching the Bloomberg Law Bankruptcy Review. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. Two really interesting items to go through today. First up, we're going to talk a little bit about venue, specifically the Patriot Coal case. The press is reporting that the Department of Justice has been on the warpath as of late with respect to getting companies to file for bankruptcy in the jurisdiction in which they're based. This has been kind of the theme for the whole year, and now it seems that this agency has Patriot Coal in its sights.
You bet they do.
What are the issues here?
You bet they do. Patriot is a big coal producer. 8 of the 12 mines are in West Virginia, and as you can guess, none of them are in New York State, and of course none of them are in Manhattan. But Manhattan is where they file bankruptcy.
And they're headquartered in St. Louis?
Exactly right. So the big question is, how in the Sam Hill do you move a West Virginia coal operator into New York for bankruptcy, aside from the fact that probably the major creditors in the case all want it in Manhattan?
Yeah, you can't exactly pull a Winn-Dixie and open up a coal mine in New York the day before you file.
Well, what they could do before they file, and what they did do, was within about a month before bankruptcy, they incorporated a couple of subsidiaries under New York law. And the way the law works is you can have an itty-bitty tiny subsidiary. That's the first one to file. You file it in New York, and then all of the big mama companies follow in New York. Well, the U.S. trustee doesn't like this one little bit, and nor, for that matter, does the Attorney General in West Virginia. They are among those who have filed motions to send the case to West Virginia, because they say this is, well, actually, it's not a violation of the venue rules. Oddly enough, the way the rules are written, having a case in New York is perfectly appropriate because of the subsidiaries that were incorporated in New York. The question has to be for the bankruptcy judge, is it in the interest of justice, whatever that means, or for the convenience of the parties to have the case instead in West Virginia? Now, looks to me like this case really puts a lot of pressure on the bankruptcy judge, because Lord knows, I'll bet you dollars to donuts that the major players in the case all want it in New York. They don't want to have the case in West Virginia before a judge who's likely never had a case of this size. Problem is, if he keeps the case in New York, he is opening up the federal judiciary to criticism in Congress for allowing a big company to escape its home state. And the difficulty the judges face is, if they do, like in New York and Delaware, keep these cases, you run the risk that Congress is going to change the rule, and there's no appeal if Congress changes the rule. And that would be devastating for courts, especially in Delaware and New York. In Delaware, they have now, I think, 6 judges. If you could only file where your head office, that would mean Delaware probably would only need 1 bankruptcy judge. New York, I think, has about 6 judges, too, right now. May very well be that this city might need only 3, maybe 4 at most.
Right, and there's big money at stake. Big cases bring big dollars to jurisdictions like SDNY and Delaware. Exactly.
Bankruptcy is a very major industry in Wilmington, Delaware. So there is big money going on this, and methinks that there are more issues involved here than whatever the Sam Hill, the interest of justice and the convenience of the parties means for Patriot Coal creditors.
Bill, I know it's really hard to say, but at the end of the day, is Patriot Coal going to stay in New York, or is it going to West Virginia?
I think the bankruptcy judge, and I'll give 50 to 60% odds, will send the case to West Virginia, not because of the recent incorporation, but because he's going to find a bunch of facts that will allow him to conclude that indeed West Virginia is more convenient, especially because of the environmental issues that are always entailed with coal mine operations.
Bill, before we jump real quick, I wanted to talk to you about the recent filing we just had with Mark Shale. It's a clothing retailer based in Chicago. They have a couple stores in the city. This is their second filing in recent memory. Anything jump out at you in this filing?
Well, yeah, it was kind of interesting in the sense that they filed once before in 2009. They had 8 stores then. Some of the existing owners were in the group that bought the company. When they went back into bankruptcy a few days ago, they have only 3 stores, which I guess goes to show you that getting smaller, at least perhaps in retailing, is not a way to assure your long-term success. Also, this raises the general subject of recidivism. And our friends from Fitch Ratings came up with some really, really interesting statistics. Among companies that have, within the last few years, defaulted on debt, they say there are now 31 companies at material risk of defaulting a second time. Now, that was interesting enough in itself, but they went on to say that in these circumstances where you have a subsequent filing, in about half of the cases, the first default was through a distressed debt exchange, which I guess is another way of saying that having one distressed debt exchange is not any insurance that you're not going to have a default sometime in the future.
All right, we'll have to see how it goes. Bill, thank you. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just discussed, be sure to check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Pacchia. Thanks for watching.